Good morning, everybody, and thank you for attending this webinar. As you know, waste is a big topic in the chemical industry, and continuously we are engaging with the department. And I want to say thank you to Michelle and her members of her department for the continuous engagement with us around some of the areas that we are concerned about. So for today's session, we really wanted to look at the National Environment Management Waste Act. We've had numerous questions from members over a period of time, including our waste working group. These issues have been sent through to Michelle and her colleagues, and I'm sure will then be covered in the presentation today. But I want to thank the department, as I say, for their continuous engagement with Kaya and for availing themselves today to this webinar, which is critical for the members of Kaya. So Michelle, thank you very much, as I say, and to the members who are attending.
Thank you, Deirdre. And good morning to our members and to our colleagues at the department. Michelle, would you like to introduce your team and start your presentation?
Yes, good morning, colleagues, and thanks, Deirdre, for setting this up, and thanks, Julie, for hosting or facilitating. I think most of you know me, but just for those that have not heard me speak before, my name is Michelle Govender. I am the Chief Director responsible for hazardous waste management and licensing within the DFFE. I kind of preempted some of the questions that might arise. So I also brought along some technical experts in my unit, so that if there are any operational questions that need attention, then I've got people here that do the day-to-day. So in licensing, we've got Ms. Cynthia Baloy, and any licensing related questions, she will be here. I also have the Director Licensing, Machulele Paladi. He is here to answer any particular questions on the licensing side. Mpho Morudu, who's here from the Hazardous Waste Management team. I don't see him on the call yet, or maybe I've missed it, but he is going to be here to deal with those aspects. Then we've also looked at not just the hazardous waste management and licensing issues. We also have heard the comments and queries raised by Kaya on the policy side of things. So looking at the National Waste Act, where we're going with that, the National Waste Management Strategy, data in terms of how we manage this in the department, any changes there. I know also that there's a big interest in terms of the waste definition and extended producer responsibility and what's happening on that front. So my colleague Gaute Makwena will be dealing with those aspects. So if there are questions related to that, I would say just hold on to them. And when he does his presentation or the second part of the presentation, then you can raise those questions. We have also heard Kaya ask us what is happening from a compliance point of view, from an enforcement point of view, in terms of both hazardous waste and general waste. And we've got colleagues here, Victor Loate, he's the Director, Sector Compliance, and he's going to share some experience, some thoughts, some issues that he has found with his team. And then, of course, we've got the enforcement side with some really good case studies, but I think the question and answer session for me would be most interesting. And we've got Mr. Grant Walters here, who is the Director Enforcement. So we've come with a big team Julie, and we're hoping that this is going to be a really, really fruitful session. I will kick things off. So let me then start. So basically, some of the questions that have come up on the Waste Act itself is how does the different spheres rather of government fit into each other, and what's their roles and responsibilities? And I thought, let me just quickly clarify that. So firstly, the National Department is responsible for a number of things. Firstly, to set the policy, develop the legislation, develop the strategies in terms of how we want to take the country forward when it comes to waste management. Now, we don't do this in isolation. We are actually the lead department, but we work with the provinces, we work with the municipalities, with SALGA when we set these legislation. But of course, we also have to look at what are the priorities of national government in this regard. So starting from the Waste Act, we've developed that. We've developed the National Waste Management Strategy, which is the blueprint essentially in terms of how we want to implement the Waste Act. And under that, we've got various sets of regulations, norms and standards, best practice guidelines, etc., that we set up, which is aimed at easing implementation. And one of the other things we do, sorry, I'm just getting some water, is that we set these norms and standards so that it avoids or it lessens the administrative burden on applicants by, if you register for the norms and standards, for example, norms and standards for storage of waste, which I'll come to a little later. Once you register with the department, you immediately implement. And so that process takes anything between 1 week and 30 days, essentially, unless there's really glaring absences. So it's a very short process to get the norms and standards registration as opposed to licensing, which takes longer. It's based on timeframes which are legislated. However, a large part of the work is done by consultants, and the department can only control the timeframes that fall within their space. So, but I'll come to that in a little while, because that was an area of interest. We looked at the classification regulations with norms and standards. I'll come to that as well. And as I indicated, the National Waste Management Strategy, which basically says, how are you going to actually implement the Waste Act? So that is the National Department from a policy, legislation, and strategy point of view. Then we come to the regulatory function. So essentially, from a regulatory point of view, the National Department would set or develop the waste management activities. And just as a matter of interest, we have a couple of days ago, in fact, this week, we have a document that was gazetted for public comment on an amendment to the waste listing notices. So I think this is an opportunity as well for Kaya members to have a look at it and provide their comments within the stipulated timeframes. This will also aid us in trying to streamline what is there and clarify why we write the activities the way they are. You would have seen, if you've been in this space over the last 10 years or so, or more actually, that we've significantly reduced the number of activities that require licensing. And we've been able to do this by having norms and standards in place, which then what we say is, if you register, you comply, then you don't need a license. So we've been constantly, kind of trying to streamline this licensing process. And just a heads up, I'm giving you something that isn't even in the public domain yet, is that we are trying to further reduce the way in which licenses are licensed activity or activities will be assessed. So we're trying to bring down the timeframes even further, reduce the the process from going full scoping to just basic assessment. But this is all with the aim of ensuring that there's a short process, it doesn't burden anyone, and that licenses can be issued much sooner. But we like I said, it's not in the public domain yet. There's a lot of work we're doing behind the scenes, but it would be imminent at this stage. And then, of course, we identify priority waste streams. Like I indicated, Gauta will talk about EPR later, but we've identified priority waste streams which are filling up our landfill sites, like paper and packaging, like electronic waste, which is banned from landfill, but still finds its way into the landfill sites. So tires, for example, and then we've got lubricant oils. So all of these are priority waste streams, which we have said we need to do something about. And that's where we have developed extended producer responsibility schemes, which are being implemented at this stage and at varying levels, because we have staggered them as well. One thing I must point out, but I think Gauta will come to it as well a little later, is that it's not a perfect process, colleagues. I think we must acknowledge that, but we are working daily on trying to improve this, and comments that the sector and people out there make actually help us streamline and really focus the legislation so that it does not administratively burden people too much on this, but we will talk about that a little bit more. So that's on the regulatory functions. Then we've got the licensing and authorization functions, and I think I've talked about this, but we issue licenses for activities that are cross-boundary. So if it affects a corridor between, let's say, Mpumalanga and Limpopo, then because it's transversing or crossing two provinces, that application would come to us as the national department. State-owned entities licenses will come to us. And then the other issue that I must stress is that anything that has a hazardous waste facility will come to us for processing that license. And of course, the DFFE is also the appeal authority for certain decisions. You would know that the Department of Mineral and Petroleum Resources also has waste activities that happen within where mining is happening or is captured under their definition of mining activity. And so they are the competent authority for that particular waste management or processing of the waste management license, but our minister remains the appeal authority. So if there is somebody out there that appeals a decision made by the DMPR, then our minister will be the appeal authority on that one. So that, in a nutshell, is the DFFE responsibilities. Let me now, sorry, I forgot the compliance and enforcement. But they will cover it, Victor and Grant, when they present. But essentially, when we issue licenses, then the monitoring and enforcement in relation to those licenses is done by our compliance monitoring and enforcement teams. They've got different names, and apologies, colleagues, I'm just using very generic terms. So they are, I think all of you have heard of the Green Scorpions, and these units actually have the most scorpions in terms of environmental legislation. They don't just focus on the Waste Act, they focus across NEMWA, NEMA, I should say NEMA, and all the specific environmental management acts. And of course, I think maybe this one is a little bit misplaced. The National Information Systems is not SAWIC. SAWIC is actually maintained by us within waste, but they have systems within enforcement and within compliance that they implement. And this gives I think when every year there's a report that is published in terms of how we're doing on a compliance and enforcement side, but the team will talk about that. And also one of the other things that we do is support and coordination, because we have to guide provinces and municipalities in terms of how they implement the legislation. And that conversation happens through structured bodies like what we call Working Group 8 for the waste side, Working Group 5 for the impact assessment side, Working Group 4 for enforcement, and there's the Working Group 2 for air quality. So this pretty much brings officials from around the country together so that we could discuss this. One of the other issues that we do is coordinating international obligations. And in this regard, I think most of you know, the Basel Convention, which is a convention that South Africa acceded to in 1994 already. And it is something that we look at, and we monitor what is coming into the country, what is leaving the country from a waste perspective. I am the focal point for the Basel Convention in the department, with Sharon being the competent authority, Sharon Mokhomotsi in hazardous waste management. So we are involved in these negotiations in terms of the convention articles, technical guidelines, etc. And we control what comes in and goes out of the country. So in that regard, when an application is made, we within the department process these, we call them consents, which basically allows material or waste to come in from other countries. I think an important aspect to note here is that with the Basel Ban Amendment coming into force in 2018, somewhere around there, we have basically stopped accepting or allowing any waste to come from developed countries into Africa or into South Africa. That is because there has been a large number of people and facilities bringing in material into Africa as a whole, and it's being dumped in the Niger Basin, in Ghana, in a lot of places. And so the Basel Ban Amendment was to stop the developed nations from taking their waste and just dumping it in Africa, and we participate in the engagements in that regard. And what we do help with is, for example, we've got a bilateral or an agreement, multilateral or regional agreement with SADC, for example. South Africa has engineered landfill sites, for example, which are of pretty high quality and performance. And we help our neighboring countries if they are unable to treat and dispose of their waste in their countries. This is all with the aim of protecting the environment. But we can have lots of discussions about that, but I just thought I will let you know. Now, in terms of provincial government, they are responsible for implementation and regional planning. So they develop waste plans, provincial waste plans, which align with the strategy that I talked about. They ensure integration with the provincial development planning. From a licensing perspective, licensing is a concurrent function. As indicated before, if the activity is does not have a hazardous waste activity happening in there, then all those license applications will be handled by province. And they, of course, conduct impact assessments for waste facilities, for example, if you've got a massive regional facility. So the licensing responsibility sits with the provincial government. They also monitor compliance with their licenses that they issue. They also follow the waste regulations and standards, and then take enforcement action where necessary. They also support municipalities from a technical perspective, from a capacity perspective, and also from an oversight to ensure that municipalities are complying. I know this is a difficult one from a resource perspective, but that is something that the provincial departments do. Also, what they have to do is to coordinate and collect all of these reports that come in from their clients, if I can put it that way, report it into the national systems. We mentioned SAWIC earlier. The Gauteng department has its own waste information system. The Western Cape has its own waste information system. So IPWIS is a Cape Town or a Western Cape thing, and GWIS is the Gauteng information system. And these systems collect data from a waste perspective and input it into the national system so that we have a fairly good idea of what waste is collected, what is disposed of, what is recycled, what is recovered, etc. So that is the waste information system. Now, let me maybe just explain, sorry, I think I missed out the municipalities there, but the municipalities develop bylaws and must follow the requisite processes. If they have landfill sites that they are building, they would have to apply, and that would go to province. So municipalities, bylaws, from a planning perspective, developing integrated waste management plans, and of course, just monitoring what is happening on the ground in their space. From a licensing process perspective, because this is one of the things that also got asked, it's a little bit colorful, if I can put it that way, but here in a nutshell, this is what happens. So you've got the listing notices that I talked about. So those have listed activities in it. That then needs to be done, or when there's an applicant that wants to apply for a particular activity, that applicant would have to appoint an environmental assessment practitioner who knows this waste space. And at that level, the environment, or the EP as we call them, would identify potentially which listed activities would be triggered. They would also identify who the licensing authority would be in this regard, because if it is an activity with non-hazardous waste or a type 3 or type 4 waste, the licensing authority would be the province, and they would then have that pre-application consultation, if necessary, with the requisite licensing authority in order to ensure that they have identified the activities correctly, and they then start the EIA process. They would then submit a waste management license application to the department, to whichever authority it is. They would also do public participation in that process. And once they have done that, completed all of that, they submit the completed documents. I've left out some steps here, but I wanted to just give you a broad overview of what happens. And if there's something you want it specifically, I've got my team here, they will do it. Now, once the documentation, whether it be an EIA document or a basic assessment, the authorities will review it. And I've got this massive red arrow in the middle here showing that where the activity also transgresses, or not transgresses, but goes over into the water space, for example, if there's a landfill that's going to be built, let's say a Class A landfill, the DWS is a competent authority. Remember, it's if you build a landfill, it's potentially a Section 21G activity that is triggered, and that would require a water use license. But in terms of the Waste Act, we have made an agreement with the DWS that says they will dispense with their requirement for a water use license for if the activity is only a 21G. Then they would issue us a record of decision, and we would incorporate that conditions of the record of decision into our waste management license, and we issue it. Otherwise, you would have to go, or the applicant would have to go through a separate water use license process, which could take a very, very long time for all of that information to be done. So we would not issue a decision because that's the way the law is written. without input from DWS. And I think this is a little bit of a snag that's going to come up in the question and answer sessions, because I've seen it come up previously as well, saying that it takes too long for DWS to process this, and that delays business, etc. So we are working on that. Just to preempt your questions, we do acknowledge there are some delays from a DWS side, some very significant delays I've seen with certain companies, but we are addressing that. They have resourced themselves quite significantly over the last, I would say, 6 months. So they are catching up on the backlog that sits with them. So just be patient with us, but we are getting that done. Over and above that, we are trying to, on our side, appoint our own engineer to help us screen the documents that come through, and also provide a preliminary kind of recommendation before this gets to DWS, so that you know, it's easier on their side as well for from assistance. And we have we have a mechanism of how we anticipate that work would be done. So that is something that we're working on. So once we get the ROD from DWS, we incorporate it into the license conditions, and we issue a decision if the decision is positive. Of course, if the requirements are not met in terms of the license, we would then issue a rejection or a refusal decision. If we reject it based on certain aspects being incomplete, applicants have an opportunity to immediately correct that and resubmit. But if we refuse an application, which is a very important thing, then the applicant cannot apply for that same activity for a period of 3 years. So I think this is something that needs to be taken very, very seriously, and which is why we would rather reject the decision if there's information incomplete. But if we constantly get incomplete information on the same application, we would be forced to issue that refusal, and we have done so. So that means it stalls that development for 3 years. You cannot do anything in that regard. We issue these licenses with conditions, and we ask that the license holder comply with the conditions, read through the conditions. Don't let the license be a shelf document, because there are sometimes areas in the licenses where the conditions may not be, according to the applicant, implementable or measurable. And that's the opportunity that you have to come back to us and say, please, can we have a discussion on this, and we will entertain that, we'll accommodate that, and we'll try to resolve that issue. If there are, and once those licenses are issued, the applicant has to notify interested and affected parties who have the right to appeal that license on various grounds. The appeal provision is provided in the license, and once that appeal is submitted to the department, it suspends the license until the minister makes a decision on that appeal document. And once that decision is made, it's communicated, and then based on whether minister upholds the appeal that is made or upholds the department's license, then the facility can either continue to operate, or it cannot start, and then you can take that on judicial review. From a compliance perspective, obviously, we've got compliance and enforcement here who will talk about that later. But essentially, if you comply with your license continuously, we come out and we have monitoring committees, or we attend monitoring committees. We look at your external audit reviews that are done. And if all goes well, we can, after that license has reached its end, or rather, let me put it this way, we have a condition built into the license that says we want these licenses reviewed every 5 years. We usually issue a license for 10 years. When we review at that 5-year period or a little bit beyond, And if everything is in order, we can vary that license to extend it for another 10 years if all of the requirements are met and the environment is not being polluted. So we have that provision as well. And if they, like I said, if there are conditions in the license that may not be applicable because of changes in the environment, changes in various issues, we are always willing, please bring it to our attention and we will have that discussion. So let's then come to some of the other aspects, this one relating to somewhat to classification. So we have the waste classification and management regulations, and we've got two sets of norms and standards with those regulations. The regulations basically classify using different formulas, and of course, following the globally harmonized system of classification. It classifies waste from a handling perspective, and I think this is an important note. So we classify for handling. When that waste, so it's essentially how is it handled, what is the PPE that's required for people that are handling this waste, where should it be, how should it be stored, etc. So that is the classification part for handling. When that waste can no longer, or rather, let me put this way, nothing can happen with it. It cannot be recycled. It cannot be reused. Then it requires disposal into a specially engineered landfill site. Now, what happens there, and this is under the norms and standards for disposal, one would have to do an assessment for disposal. So the assessment tells you if it is a type 1 waste, it's high risk, and because of the high risk, it requires a class A barrier system. So that's the way it works at this stage. Type 0 means it exceeds all the values within the norms and standards and the regulations, and thus cannot be landfilled in its current form because the risk of leaching, the risk to the environment is too high. And so that we don't allow for landfilling. That waste must be treated to bring it down to either type 1 or even lower before it can be disposed. And some waste streams, I think there is maybe this misconception about the way the waste is assessed, because by right, the Waste Act should not now be referring to general and hazardous, but we still have it in the Act. And I think this is something that we are looking at amending, because the regulations are more accurate from an international perspective that says we should actually not call it general and hazardous. We should actually refer to it as the type of waste, because the type of waste will determine exactly what kind of containment barrier is needed. So if it is a type 3 waste, it is a low risk waste and you need a class C liner. But that liner is needed because it is not non-hazardous. Non-hazardous means inert. It means type 4 and can go to a hole in very minimal, like a clay liner lined facility. So I think those are the things I wanted to highlight here, but I'm sure that there will be questions based on some of the activities that we have looked at and the facilities that we have dealt with. So essentially, a municipal landfill site is supposed to be a class B because there's a lot of things under the municipal solid waste that has the potential to leach out and affect the environment. So this is one of the later amendments that were made that municipal landfill sites should be a class B landfill. We've got 7 or 8 landfills in the country on a Class A basis. They are strategic assets for the country, and they deal with things that cannot go anywhere else. And like I said earlier, some of our other countries, neighboring countries, also utilize these landfill airspace. Colleagues, let me then, I'm almost at the end. I know I've been speaking quite a while, but I'm almost at the end. Let's then look at the norms and standards for storage of waste. I think one of the things I want to say here, which is something that has raised, is there's a misconception of the 90-day storage time limit. So essentially, that 90 days is called temporary storage, right? So if you are storing waste once off for a period less than 90 days, then you don't actually need to register with the norms and standards. But if, and that becomes temporary storage. But if you are going to store something for probably 30 days, and then it's removed, but then you continuously store in that area. So that stops being a temporary storage. It becomes a facility that you are using for storage. And hence, if that happens, one would need to apply or rather register with the norms and standards for storage of waste and comply with that. I think the storage method, making sure that there's closed labeled containers. And it basically, what I've done here is I've just taken which area, what is the key requirement and why it matters. And I'll leave that with you for digestion, and you can come back to us. But there's 2 other things that I want to mention here, which seems to have some sort of confusion. When it comes to hazardous waste, and if you're storing in excess of 80 cubic meters, or rather, let me say your area for storage has the capacity of more than 80 cubic meters, that requires registration with the department. If it is less than this, and I'm talking about the capacity of the site and not the actual waste that you're storing there. So if the capacity of your facility is maybe 30 cubic meters, you don't require registration in terms of the norms and standards. What you would need to do is comply with the duty of care provisions within NEMWA and within NEMA. So I think that is something that needs to be mentioned. And if you've got questions on that, my team is here. And the same applies to general waste, because even though general waste, and like I said, here's the issue of general and hazardous coming up again. But if the waste has really a low potential to impact, then we have a bigger storage trigger, if I can put it that. So instead of the 80 cubes, we're saying if you have general waste that is stored for more, or the capacity of the storage facility is more than 100 cubes, then it would trigger the need for registration. Remember, let me go back to the licensing requirements, because norms and standards is actually a category 3C activity under the waste listing notices. And essentially under Section 43 of the Waste Act, I indicated its concurrent functions. So what this means is that if you've got general waste storage, the registration is usually done by province, unless the province has communicated to us that they have issues and we help them. But the common practice is, if it's general, it's province that does it. If it is hazardous, it is the national department, unless there's an agreement. But speaking to the officials would highlight this. I'm hoping that clarifies matters. Okay, so like I said, I'm right at the end of my presentation. Let me also, maybe while I have the floor, talk about maybe just a couple of things related to, there's one thing, right? So this is the issue I wanted to raise, but I realized much later that I didn't add it into the presentation, and that is the transport issues when it comes to waste. Now, we have had a look at the Department of Transport regulations. And the transport regulations are quite intense and quite adequate for facilities that are transporting hazardous waste, or it's classified under the Dangerous Goods Act as well. If that happens, the applicant or the person wanting to do this must comply with the Department of Transport regulations and all the norms and standards, and they've got about 30 pieces of legislation which control this. Now, from a national perspective, we didn't want to reinvent the wheel. If we've got the Department of Transport working quite well to cover aspects that fall under us, we have basically said, follow the Department of Transport regulations. We would not issue permits, as it were, for transport of waste. However, that is the national department. What we are working on at the moment is activating Section 25 of the Act, which basically means we're looking at registering all of the transporters, but we have not brought that live yet. That's going to take a bit of time, so we'll still look into that. And my second point I wanted to make here is that the Western Cape and Gauteng do have requirements for registration for transport. So if you are bringing material into Gauteng or taking it out of Gauteng, and the same with Western Cape, then one would need to apply to those authorities for a transport permit. Other than that, all other facilities across or provinces across the country do not require this at this stage. So let me then stop there, Julie, and hand back to you.
Well, thank you, Michelle. Thanks for that very comprehensive overview and some insight into new developments. We do have some questions in the chat that regarding the powers delegated to the minister. Confirmations required if this includes exemption applications under Section 74 of NEMWA.
Okay, I see the questions. You want me to answer all of them,
Do you want
Julie?
to work through them? Yeah.
Yeah, okay.
That would be great. Thank you.
Okay, perfect. Okay, so let me go to the question from Vicky, which says, regarding the powers delegated to the minister, please confirm if this includes exemption applications under Section 74 of NEMWA. Yes, for hazardous waste activities, that Section 74 would sit with the minister. And the minister has, in fact, delegated that powers, or his powers, to our DDG. So it's actually much shorter process, but also one of the things that we looked at and advised Minister on is if he is making a decision on Section 74, it removes him as an appeal authority and it brings the courts into play. So essentially, you're pretty much giving away your function to the courts to decide. And based on that, he has delegated the function to DDG Chemicals and Waste, Ms. Mamukhala Musekene, and that in that way, if there is an appeal on the decision, it then gets elevated to him for him to consider. So it keeps, it gives him an opportunity to then re-look at the matter. So I hope that covers that. The second question from Vicky is, do these lining requirements apply retrospectively? No. So what you need to understand, Vicky, is if you read the classification regulations and the norms and standards, and the regulations came into effect in 2013. So between 2013 and 2016, applicants or users or owners of these facilities were allowed to still operate under the old regime in terms of the liner systems. However, if that particular site needed to be continued after 2016, then one would have had to do a piggyback liner to meet the current requirements. So that is what has happened for some cases, but I do know there were issues raised from, for example, municipal sites, which took a long time and went beyond that 2016 deadline. But just to come back to the, to complying with the more to move from a GLB plus liner requirement to a class B, and there's a few differences there. So it does not apply retrospectively. But if that site is continuing to be used, then you need to piggyback a liner on that. Okay, so another one from Frida says, is there a formal process for deregistration from the norms and standards? Say the facility will no longer be used or there will be changes. What is the official process? So I think here you would need to liaise with my team, because if the facility is no longer in existence, you'd have to surrender that. But I think that is something we are looking into, and my licensing team is here. They will take note of this, because in this financial year, we'll be re-looking or revisiting the norms and standards for storage and build things in if there were deficiencies. And this would be an opportunity for the sector to get involved. And I think maybe Machilela, just take note of this. And Frida, if you can, maybe you've got my contact details there, just reach out and we'll be able to deal with you. Okay, then I see that, okay, so I've handled the ones on the chat. Julie, back to you.
Thank you. I see Johan's hand is up. If we could unmute Johan to ask his question, please, Samantha.
Good morning, Michelle, and thanks for the presentation. Michelle, a suggestion on this dilemma versus hazardous versus general that ends up tangling so many people. If we think about it, we're using the GHS system as our second point when we're dealing with waste to make the decision, is it hazardous or non-hazardous? And I would like to suggest that we start using the term non-hazardous rather than general, because the GHS has no description for general. It says something is either hazardous material or non-hazardous material, and I think that's going to make people's life a lot simpler if we start using, let's call it, the correct terminology as per GHS. Just a suggestion from my side.
Thanks. Through you, Julie. Johan, thank you. And I think we've had this discussion many times, and Johan is one of our, we did this collab between industry and ourselves when we were amending the classification regulations and the norms and standards, and Johan was one of our co-chairs. So thank you for that. Johan, what you say makes perfect sense. And we are moving towards that, but the wheels turn very, very slow when it comes to the amendment of legislation. And all of us here that were involved in the NEMWA process, you would have been ready to tear out hair, because it took about 9 years before we could get the very, small amendments that we were trying to make on the Waste Act, for example, on the remediation aspects. So this is the way we're going. This is planned for NEMWA 5. This is, we're internally reviewing the Waste Act to, identify areas that require attention But I cannot tell you it would happen in the next year, but it is on the cards. And I agree with you, because as soon as we move away from the general and hazardous, we really negate a lot of the complaints and queries and that are coming in. But thanks for that. We do have it. We are taking it forward, and maybe this is an opportunity as well to ask the sector to drop us emails in terms of any other aspect relating to NEMWA that is problematic or may require attention, so that we could internally look at it, and then when we start the consultative processes, look at how we deal with that. And I would further encourage that if you're saying you have a problem with section 16, for example, then you say, here's what section 16 is requiring on the duty of care. This is what we do. This is the problem we have. This and then finally, this could be a potential solution. And I think that helps significantly, Julie, in terms of taking this forward. But like I said, this webinar is a great opportunity, and we have to have more of these going forward, more focused discussions. Back to you, Julie.
Thank you very much, and we'll definitely take up that offer, and I'm sure Kaya will work with the members to coordinate input into these processes. I think, we have one further question from Muma.
Thank you. Thank you so much for the presentation. It is really well, the information is really great. I just want clarity. I don't know if I missed the answer or the explanation with regards to transporting of waste between provinces. Did you say that you can transport waste from a facility, let's say in Limpopo, to a facility in maybe Johannesburg? Did you say you don't need a permit anymore?
Okay, through you, Julie. Thanks, Muma. No, what I said was, if you transport, let me use this example. If you transport from Mpumalanga to Limpopo, there's no requirement from the national department in terms of a certificate or a permit for you to transport. However, once you transport into Gauteng or out of Gauteng, the provincial department, which is the GDAD, would issue you a permit because you're bringing the stuff into Gauteng or you're taking it out of. The same applies to the Western Cape. So the Western Cape, if you're bringing something into the Western Cape or taking something out, you would require a permit from the provincial department. Those are the only two provinces in the country that have this requirement implemented at this stage. If you're traveling between the other provinces, you don't need a transport permit. You have to just follow the Department of Transport regulations and norms and standards. And I think, Gauta, maybe when you start your presentation, you can allude to what we're doing in terms of activating Section 25. So Muma, we're looking at in the future having a register of all the hazardous waste transporters across the country, but we haven't activated that section. I'm hoping I'm clear on this one. Thank you.
Sure. No,
Julie,
thank you
back
so much.
to you.
Thank you.
Thank you very much. I think if there are further questions that come to mind, just pop them in the chat, and if there's time at the end of the presentations, we can go back to them. Michelle, are we going to be moving on to Gauta's presentation now? Yes,
Gauta, if you can share and continue. And I think, Julie, I'm wary that we finish at 12. So if Gauta, maybe if you can limit your presentation to about 15 minutes, which would then give opportunity for comments, and then also the compliance and enforcement team to present. Thanks. Over to you, Julie.
Thank you very much. And thank you, Gauta. If you'd like to share your presentation.
It's a continuation of the discussion we had last year, and Thank you very much. Good morning and good morning to the members and colleagues. Last year when we met, we're talking about the amendments on the Waste Act, among other areas, and hence my request an opportunity again to just update you on the few areas that we have went through and thought let's have a discussion with yourself as well on progress on where we are, and obviously the EPR implementation remains one of those that is our discussion as we continue on the implementation of EPR. There are new areas as well that might not be on the slides, but from our discussion, there is progress on them in line with what we discussed last year. For instance, our preparation for the implementation of the Section 80. At the time, the Section 80, we presented it as part of the transitional arrangements that needed to be put in place to bring under the ambit of all previous permits, authorizations, and licenses that were done in terms of the old pieces of legislation so that they can be under the Waste Act. Hence, my intervention today is largely to give progress update on some of these areas and request your further inputs as well on some of these. So as an outline, we have the purpose, background, legislative framework, EPR as indicated, the key developments on performance, progress made, systems-wide challenges and future priorities. I'll also we received as points that you wanted us to discuss as part of my presentation. So as indicated, this is the purpose for us of engagement on policy, EPR implementation, waste minimization, implementation aspects of our EPR or other aspects of legislation, and hence the need for us to work together either in the revision of legislation because we are amending legislation. There are new policy instruments that also come into the sector being introduced, and also there are similar developments and updates on the South African Waste Information System, either for registration of the facilities or the is that would have been licensed or leaded in the waste activity list, which we are from time to time also updating. EPR and waste definition being some of the points that we'll be looking at. Safe to say that on the state of waste, for instance, this year we are commencing with the review of the state of waste report of 2018, which we have developed based on your inputs and contributions. And thank you very much for the collaboration and working together up to this far. Legislative instrument, we met last year also in person where we discussed in detail the waste amendment bill and also what can be done as improvements on areas such as the use of the word object in the definition of the 2022 bill. In the 6 or 7 options that we had last year, it was option number 4 And how do we clarify areas of waste traded in? How do we clarify areas of waste used for commercial value? So we are requesting considerations on how we can move forward in further crystallizing on these areas as we've discussed, and we have raised it in the stakeholder consultation process that maybe the word object might be too broad, and we do agree, and hence in order to try and narrow it down, we're saying as a proposal, waste means, or an object means, in this case, to contextualize, means materials or substances identified or prioritized by Minister for EPR in the Gazette. But we will appreciate to hear from you on your views and thoughts as well. Waste traded in, we're saying as a proposal, meaning waste used in circular economy and waste recycling and reuse value, because ladies and gentlemen, is that in our EPR, we have included in the definition of the producer, the importer as well, which is where potential for the waste traded in coming in. The other one is the waste used for commercial value or commercial purposes. So it's saying meaning waste changing ownership or also are used for the purposes outlined in a permit or authorizations. We're saying this because we are issuing exclusion authorizations, for instance, for certain materials. So hence, if your material is intended for that purpose, it is excluded from the definition of waste, and hence it is the materials we are saying, let's find ways to try and crystallize to say in the definition of waste, how do we narrow the scope to exclude that in the waste value chain. Legislative framework also for EPR, as we all know, being based on the Constitution, based on NEMWA, the Section 18 that we currently are implementing, and the EPR regulations that came into effect on the 21st of May, and they are currently being implemented. And we are busy with the revisions of the regulations as we speak, based on the consultations through, among others, yourselves. Last year, we had major workshops as well on the proposed regulations. So we are looking at revising this a bit on the systems as well. We have on the SAWIC EPR portal for registration of producers, as well as producer responsibility organizations. So hence the data from there give us this picture in terms of registration of producers and producer responsibility organizations, as you can see on the screen. The developments in terms of EPR schemes, we have the 6 EPR schemes. Work is underway in terms of, remember that definition of or clarification of the scope for the object. We also saying there, as an example, if minister has prioritized certain waste streams, those waste streams and products will be the products that the is referring to. And in this case, as an example, the 6 waste streams or products from resulting in the waste in the 6 waste streams are as an example, instead of us having a definition of waste that covers all objects. That was definitely not our intentions. But so there is a national system on service currently on EPR as well, is only at national. There are discussions in terms of the waste picker registration, also for a national system for the remuneration of the waste pickers for their participation in the EPR scheme, and hence the updates and the developments on the SAWIs that we are using for EPR as well. It can be on a number of these aspects that are highlighted, including collection systems and linking with Western Cape, as well as Gauteng systems. There are issues of integration of the informals we have in our implementation of the Recycling Enterprise Support Program, conducted a socio-economic impact assessment study to have a sense of the benefits or the impact of the enterprise support that we're also encouraging PROs and producers to continue implementing on the different communities and areas where they are implementing. And we have found that if you assist one enterprise or SMME, the benefits and the impact is received, or the benefits are received by more than that person, because we find that that person was employed in a particular enterprise or as a director is supporting 10s or 20 or 30 or more other people in the communities where they are. The issues of financials and socials coming into the play in terms of performance, noting, ladies and gentlemen, that currently on the 6 EPR schemes, we're collecting revenue through producer responsibilizations. The producers who are implementing their own schemes are not collecting revenue, but they are setting aside budgets for implementation of their schemes. Some of them being deposit refund systems or the DRS. So we have the lighting, paper and packaging, electronic waste. We have the lubricant oils, pesticides, as well as portable batteries schemes, and the slides indicate the elements at this stage as we are on the year of 5th year of implementing the EPR scheme, also near the review. The regulations requires the review of the scheme every 5 years, and hence we are looking at starting that process this financial year. Job creation is quite key, as direct jobs in the form of waste pickers who are supported, and behind these there's others as well in the form of their families or those who are supported through the services between the waste pickers or their families in terms of whatever trading that might be happening with the income that would have been received from waste as a resource, and participation in the EPR schemes or excluded materials, because those materials will be going to add value somewhere. Then there is issues of targets as well that we have noted and monitored over a period of 5 years since the introduction of the EPR schemes in 2021 for the different materials. As you can see, for paper and packaging collection targets that are indicated. Issues of waste management, also in waste management, we are encouraging the producer responsibility organizations and other strategic partners in waste management to work with municipalities, as municipalities have their IDPs and IWMPs. They are better positioned to see how our waste recycling or circular economy projects can align with certain projects in their municipalities. This is an indication in terms of the waste diversion, which is key, because while we're talking economic contribution, circular economy, job creation, key for us is this diversion part, and hence we are monitoring these on regular basis. And as you can see as well, performance in terms of the different 6 sectors, again, the performance and participation. I think linked to this, ladies and gentlemen, what one can also link to the system is that on regulations, we are trying to provide for the deregistration of those that might be registered intentionally or erroneously, intentionally at the wrong place or erroneously for some reason, because that makes our numbers of PROs or producers to be different from the actual activities you see from the PR schemes or PROs that are indicated here, because our registrations will be showing more by performance report. You see the same PROs. Significant growth in EPR revenue has been observed between year of introduction to date. I must say it's a process and a learning curve, because we have a requirement for concurrence as well from Minister of Finance, an area we're trying to see how we can improve on. The system-wide challenges as well include the need for us to see how we can deal with issues of free riders, infrastructure, financial support. I did mention this earlier on. The data collection, hence monitoring evaluation. In the amendments, we spoke about the EPR monitoring of the Waste Management Bureau, but we received strong views against it, and hence the proposals on the table as well for the EPR monitoring agency, or an independent EPR monitoring agency. Just to emphasize, the submissions are saying it must not be an agency that is close to government, close to industry, or close to certain sectors, but it must have that element of independence to be able to service EPR monitoring and implementation in the country. So issues of compliance enforcement being key. I think colleagues from compliance enforcement will make interventions, but we are working very closely with them on areas of non-compliances, and hence we are realizing also other areas that might be improved through resources and capacity, including either through the EPR monitoring agency, where we can have capacity or even more capacity for monitoring some of these areas. Infrastructure and operational capacity I've mentioned, but infrastructure, more to say, there's no need for us to duplicate where there is equipment or facilities or resources that can be shared. Let's do that. Let's align with what the municipalities might recommend. And thank you very much. My apologies if I took longer than the 15 minutes, but open for discussion and engagement. We'll appreciate feedback as well on the proposals that are there and how we can clarify better clarity. Thank you very much.
Thank you, Carter. If there are any questions, please put in the chat or put your hand up. We have one question in the chat, Carter, that perhaps you'd like to respond to. It says, regarding the proposals for the definition of waste, is the department considering aligning the definition of waste with the AMSA judgment, which provides an authoritative basis for treating certain streams with commercial value as byproducts rather than waste?
And that's true. That's true. So we are taking lessons from all our experiences, good, and strengthen our regulatory. The request for your inputs and of further refinements on how we can better define or crystallize on what object we're referring to, what traded in means for us in this definition, and what waste used for commercial is. It will really the proposals we've received also in line with the really appreciate the engagements even outside the courts, because courts have been engaging and are engaging for us, so instead of us talking through the courts only. Thank you very much.
I think the big concern is that the process is becoming quite complicated, where it's very clear that byproducts are not wastes according to the courts. But I think further engagement is definitely required around this before you go ahead and publish a bill for comment. Is there that possibility that we'll be able to engage further?
Let me consult with our other colleagues who are running the parliament program to see what timelines are there on their side. Just a bit of background for some of the colleagues. The court ruling called for Parliament to strengthen certain areas, including the introduction of the bill. So in our presentation to Parliament, there was support for the department bill to be processed. So hence the process we are currently working on for submitting to Parliament for Parliament's consideration, and Parliament's taking into the stakeholder consultation process as well, as it was an area that was seen as being the need to be strengthened. So there will be those consultations from the department side and also through the Parliament. We can engage maybe even after this, see what approach you can use to coordinate and receive additional inputs following our discussion as well. Thank you very much.
Thank you, Gauta. So the process is proceeding with submission to Parliament with option 4, with the additional definitions. Is that correct?
To provide clarity, But there is a the draft bill that is for consequential amendments is being improved to provide clarity on these 3 areas that I've highlighted, and hence the need maybe for an engagement or a session on it as a proposal, but based on my consultation with the colleagues who are running the parliamentary program to see what they are scale and not be able to provide the certainty to say this time. But from this process and this engagement and on the proposals for the 3 areas, the meaning of the object, meaning of the waste traded in, and meaning of the waste used for commercial value, would appreciate any inputs that might be submitted. I'm just thinking time-wise. I don't know, what would you recommend? I wouldn't want to set certain times from my side without process we might be thinking about a side chair to coordinate or to facilitate inputs. So let me suggest either we engage with you, or you can suggest how we can work together on those. Thank you.
We have 2 more questions, Gauta, in the chat.
Yes, my apologies because I'm flighting. Might not let me stop sharing.
Okay, I can read the question to you from Farida.
Yes,
in
please.
regard to the previous question, what is the interim process until the amendment to the definition is finalized and implemented?
Thank you very much. Yes, interim process is that the 2014 definition is still in force because the proclamation was going to bring about the new 2022 definition. Hence, the request, maybe if there is any thoughts or proposals on these areas of refinements being appreciated. I don't know on the process, Chair, maybe you might want to suggest, or we can arrange in consultation with yourself some time just for a final look before we submit, again, depending on my engagement with the colleagues leading the parliamentary process. But I believe the timelines, I'm hopeful that the timelines will still allow us to have another session. Thanks a lot, Chair. That is on the interim process until amendments, but maybe in our further engagement and after engagement with the colleagues, we can look at a roadmap until conclusion of the process. The other question I see is, will we get an opportunity to comment on the changes to be added to the draft bill in question? We have only seen the earlier version, excluding the changes you just discussed. Yes, I think that's the session and the part I'm suggesting that we have a way of accommodating. I'm going to be requesting our colleagues working on the legislative program that at least we have a process and a way in which we can share the whole picture in addition to the different aspects that we've been discussing and agreeing upon. But we'll be working on, is it yes, that last question from Francisca. We'll be working on an opportunity for us to see the complete bill. Thank you. So we can communicate, Chair. I will provide feedback and also an indication once it has been completed to say what timelines we're looking at and how it looks like, and provide with feedback based on the engagement or result of the engagement with the colleagues. Thank you.
Thank you, Kata. I think
and thanks a lot to the colleagues for the engagement in it.
In the interest of time, if there are any other questions, please include them in the chat. Even if we don't get to them today, we can ask our colleagues in the department to respond to them. Michelle, are we moving on to compliance and enforcement?
We are. We can hand over to Victor and to Grant. Thanks, Julie.
Thank you, Michelle. Grant and Victor, the floor is yours.
Good morning to you, Julie, and to all of the colleagues from the DFFE, ladies and gentlemen. I think let me start off by just asking Mr. Luwati if he's ready to go first, and then I'll go straight after him. But good morning to everyone.
Excellent. Yeah, colleagues, I think firstly, good morning, esteemed colleagues and webinar participants. My name is Victor Load. I will be giving this short presentation on behalf of the Chief Directorate Sector Compliance in the department. I just wish to extend a warm welcome to you all. So thank you for this engagement. My presentation is more on compliance. Let me just reiterate the following. In this department, the compliance component is separate from the enforcement component. I am from the Sector Compliance Chief Directorate, and Grant is from the Sector Enforcement Chief Directorate. So we have responsibilities that are aligned, but we are separate, so to speak. So in terms of my presentation, I think one of the things that I would want to reiterate is outline that distinct yet complementary role of the three spheres of government. But what I want to say, instead of repeating what Michelle has said, is that the sphere that issued an authorization or a permit is responsible for ascertaining compliance with that particular permit, authorization, or license. So from the national department side, you know all that we are responsible for ascertaining compliance with the national norms and standard and the hazardous landfill sites. And when we come in with the provincial colleagues, we might be coming in maybe to provide support to them. But the structure is designed to ensure that compliance responsibilities are executed at the most appropriate level of government. This is basically what I wanted to indicate. Michelle has also covered the different categories in terms of the different types of landfill site. The general ones are authorized by the MECs. The province will be responsible in terms of ascertaining compliance with those licenses, and the minister is responsible for the hazardous landfill site. So we would be responsible for ascertaining compliance with those hazardous landfill site facilities, and also at the same time provide support to the other spheres of government. So in terms of compliance, this is just a small way of explaining a very complicated pathway. Our role is to get you to comply. But if you don't respond to us, it is possible for us to force you to comply, so to speak. So our compliance and enforcement pathway in terms of what we do is to detect through monitoring, complaints and inspection. We do reactive complaints. We investigate, we gather evidence and assess the risk, and then we can issue the initial notification encouraging voluntary compliance. And when necessary now, the enforcement colleagues would come in. So basically, when we do the initial gathering of evidence, we determine if what has been there or what the transgression warrants us to go to enforcement route, and they would issue an enforcement notice, and they can escalate it. And one thing that we would want to reiterate is that the serious breaches, we can also refer them for criminal, and that is something that Grant is going to talk about. And basically we operate using Chapter 3 of NEMWA. We do have joint operations as different spheres. We do have delegation in terms of provincial enforcement, local enforcement. We have formal delegation agreements sometimes. So we can be there everywhere, depending on who calls us to provide support. And as a national department, we do provide training and technical guidance and capacity training for the EMIs, and make sure that we are able to assist the other spheres of government. What is very important to colleagues in the meeting is that you need to be aware that we are basically applying a risk-based approach to prioritize our compliance and enforcement resources. We cannot be everywhere all the time. So we need to ensure that our actions are proportionate and strategic, so to speak. So we do a bit of assessment, basically. We look at different components: environmental hazardous severity, we look at public health, we look at compliance history, and then we look at the scale and the volume of the activity, and then we strategically prioritize. So that's basically what we do. So based on the assessment, the high-risk breaches receive an immediate directive or penalties. That's basically what we do. The medium risk breaches result in enforcement notices, and low risk are addressed through advisory engagement. Internally, we have compliance and enforcement panels. We have the governance structures, as Michelle has indicated, the working groups that looks at this, and we also have the IPIC, where we prioritize issues and deal with a lot of issues in different sectors. Our concern, especially in terms of the sector that colleagues are involved in, is the transportation of the chemicals in this country. We found out that that's now turning to be a critical area of concern, especially chemical spillages. So we observed that there's repeated failures by responsible people under NEMWA Section 30 to take measures to contain, clean up, and rehabilitate the contaminated sites. And this basically is often due to lack of sufficient insurance cover to conduct proper incident management and rehabilitations. In some cases, we have problems where there's not even capacity for a truck to move the transportation of that. We know for a fact that the national act that deals with that, the National Transport Road Traffic Act, have regulations that have been promulgated, and there are some regulations that incorporate the SAN standard, especially the 10231. But we understand now the challenges that is attached to that, because the standard is talking about adequate insurance cover, and I think the industry has taken advantage of looking at that, and now we are having a problem where we now have to define what adequate means. But the law is clear that when you have an incident in terms of the Section 30, you need to contain, clean up, and rehabilitate. So we do have a bit of a problem. The most interesting thing is that the companies this side are able to adhere to requirements of the transportation of these chemicals in the SADC region. So in South Africa, we seem to be the weakest link. So that is basically the concern that we are having, and I think as compliance and enforcement, we will be stepping up and involving all the authorities that are dealing with this matter to clamp down on it. The simplest one is the recent one that happened in KZN, where you see a chemical spillage, and the road has to be closed for an extended period of time while we are trying to locate who the responsible party is and but this also happens with the South African owned vehicles, South African owned companies that are transporting these spillages in the country. And we do have spillages of this everywhere in the country. But when it comes to the other waste issues, in terms of the facilities, and we don't have a problem with that. And I think one of the things that we would do is just to create awareness in terms of the waste that facilities generate and taken to the landfill site. Because there's a very big difference between a disposal certificate and a weigh bill, a manifest, so to speak. which one is having more weight in terms of you as a responsible citizen, with the responsibility that lies with environmentally sound disposal. So is a weigh bill okay? Is a disposal certificate okay? If I'm taking my waste to a facility, which one? A weigh bill, or so there's a very big difference. Those are some of the issues that we picked up. But as I said, when we ascertain compliance, we make a decision if the matter is warranted in terms of going to enforcement, and enforcement takes it over and deals with that. We can issue a warning if we deal with minor issues like housekeeping and so forth. But if we feel that there's a very big breach, then we do refer the matters to enforcement. And then I think a lot of issues that I wanted to reiterate, maybe to set the scene, Michelle has covered them, so to speak. Thanks, colleagues.
Thank you, Victor, for that overview. Will your colleague Grant be adding to this information?
Yes, is it Julie, right?
Yes.
My name is Grant Walters. So let me put up my presentation quickly. All right, fantastic, and good morning once again, ladies and gentlemen, and to the colleagues who have organized the webinar. I'm Grant Walters. I'm with the Department of Forestry, Fisheries and the Environment at a national level. My core function is the enforcement of waste and pollution legislation. And I think just with the remainder of the time and still really to be respectful of the time that has been set for the remaining of the webinar, maybe I'll just cover 3 broad points and then leave a little bit open for discussion a little bit later. So as Victor has pointed out, is that we do sit quite separate within the department. There's a compliance chief directorate and an enforcement one, but we operate under quite a novel idea that was introduced into environmental legislation in about 2006. And at about that time, when the National Environmental Management Act came into existence, it recognized the need for dedicated compliance and enforcement officials to undertake the compliance and the enforcement of environmental law. And we've gone through by, I suppose, a lot of names over the years. We are called the Green Scorpions. The legislation itself, or the NEMWA, defines the role of compliance and enforcement inspectors as EMIs. My main areas of responsibility is investigations or criminal investigations. And I'll point out to you in a second why that was necessary and what our relationship with the South African police services are. And then I'm just going to introduce quite a novel idea that has come in the way that we enforce environmental laws. We're looking at big data. As Mr. Luwate has just pointed out, a lot of the work that is being undertaken within the compliance space is prioritizing which areas needs dedicated enforcement action on. And a whole lot of our work actually involves quite a bit of coordination and planning. So just as the EMI, or environmental management inspectors, or the Green Scorpions, at a national level, we've got the DFFE, Department of Water and Sanitation, and I've highlighted the Department of Mineral and Petroleum Resources. The DMPR is specific, are also mandated to enforce environmental legislation, in particular when it comes to issuing of environmental authorizations as far as the activities linked to mining, as well as waste management licenses. We do a lot of work with the DMPR, and as you would know, recently is a spike in illegal mining that requires us to sit a lot more closer And on that front, obviously, the environmental damage is something of concern to the environmental authorities. At a provincial level, there's 9 provincial environmental departments, 7 conservation authorities, which include Sandparks, which is a national entity, and then local authorities. And I hope I have my numbers correct, is that there is quite a number of local authorities involved in the enforcement of, in particular, the Air Quality Act. That's an area of exclusive governance or exclusive authority when it comes to the Air Quality Act, although they do have certain aspects when it comes to the Waste Act. We train a lot of those inspectors, and I think across the board really is that environmental management inspectors operate as a network. I thought, let me put up just the structure of CD enforcement at the national level. It's quite an interesting area of work, is that we deal with brown, blue, and green crimes, as it's colloquially called. And as you can see at the right-hand side is the introduction of the Environmental Enforcement Fusion Center. Those are analysts particularly employed to enforce or to assist with biodiversity crimes. But what we have seen happening across the environmental legislative space is the emergence of organized crime. We realize that waste, which is particularly being discussed at the moment, is a commodity to undertake organized crime-related activities. And when we've analyzed this a little bit more closely, we've seen convergences with other crimes. So, for instance, things like smuggling with rhino horns, some of the activities on the oceans and coast space, the linkages are all the same. So the commodity is just a means to create or to undertake other crimes. So, for instance, financial crimes and the like. And so at CD enforcement, it is kind of a move a little to become more intentional about what we do. So as my colleague from the compliance unit has said, is that there's quite a busy space in the compliance area of work when it comes to prioritizing, and actually then just also to create that filter between what is intentional or negligent non-compliances and to elevate those for more of an intrusive form of investigations that then would play out. This slide just says that we have a memorandum of understanding with the South African Police Services. We meet quite regularly with them, actually on a quarterly basis. There's a steering committee that was formed to implement the requirements of this memorandum of understanding. This MOU basically gives us, to some extent, access into the policing systems. One particular one would be the CAS system. That is when you register criminal investigations or dockets. And then this MOU is also utilized to link into a system called I-24/7. That is an Interpol system where we flag individuals of interest that are operating within the waste and pollution, or specifically in today's discussion, the waste space. So what we have picked up is that these are individuals that operate in this waste space together with all of the other areas. They operate in a global space. So you've got to monitor their movements. We get regular updates in terms of that Interpol systems. And this MOU gives us quite a little bit of a relationship with the SAPs. We work with them quite regularly on the investigation of environmental crimes. And I think this particular slide just shows that at the level of investigating waste crimes, and I was listening very carefully to the discussion in terms of the definition of waste that came up a little bit earlier. When you deal with criminal investigations, the burden is on the state to prove all the elements beyond all reasonable doubt. So some of the things that sounds quite superficial requires quite a lot of, on this particular slide, you'll see skill in terms of evidence collection, where you would basically have to take it down to a level of proving that an infringement has happened. In the waste space, it's a little bit of a tricky area of regulation. So our officials do come in when we investigate those crimes. So just a typical, maybe a complaint lodged by SAPS, immediately they would reach out to the national department. That happens all the time. And we would then refer the matter to the province if it's a matter that belongs to them, or if it's a general waste, they would go and investigate the crimes. Or if it is with national, we would then step in and do a lot of the work around it. Now, as I've said, is that the commodity itself is quite different to any other environmental commodity, in that you're dealing with hazardous crimes sometimes. So things like having the correct protective gear, which we're very strict on at the national department and throughout the EMI space, as well as just understanding the very nitty-gritties when it comes to evidence collection as well. So I thought, let me put up just this slide to show just the general approach to investigating waste crimes, which I've said stands a little bit apart from all other crime areas. If you investigate biodiversity crimes, you do not sit with crime scenes where you've got a lot. In this particular issue was medical waste or healthcare risk waste, by the way, in a residential area. So our default mechanism all the time almost is to remove the risk from the environment through a set of tools called administrative enforcement notices. Those would take care of cleaning up the area. To your right, you would see that waste would no longer be there. The tool is specifically designed to enhance or to remove the risk, or to bring somebody back into the regulatory net. Whereas in this particular case, you would see that crime is listed as a zero tolerance crime. So everybody operating in the healthcare risk waste space, I suppose, would know that by now. If we find a crime scene like this, it would be coupled with a criminal investigation as well. Although with criminal investigations, the process of going through a court process, it takes quite some time. So we are mindful of that, and you can't leave a scene like that forever, for a very long time. You need to clean it up. But when you do get your administrative notices, it does not mean that we cannot do criminal investigations running in parallel to that. In the waste sector as well, what we have seen is a lot of illegal dumping that's taking place. In this particular case, it would be the Kaya Sands area in the west of Johannesburg. Our environmental management inspectors are now trained to lead quite deployment ready or deployment of multiple agencies that participate in those operations. So the lead would be your commanders when you deal with illegal dumping at the scale at which it is happening, in particular in Gauteng. It resembles organized crime, and maybe I'll just get into a little bit of a discussion on that in the next slide. But our officials are now being trained to lead these deployments, and it's not uncommon to see EMIs actually really at the front and center when it comes to dealing with these large-scale illegal activities that is happening. An interesting point on this particular case is that the MEC of the Gauteng province is very much in the lead or leading the initiative. So a lot of arrests in terms of that operations and ongoing areas of work in the pollution space happening there. I put up the slide, and it's a little bit different to what we are discussing, but a lot of work is happening at the Fusion Center. This is the one analytical unit that is being used to analyze big data. As Mr. Mokoena has just said, is that we're looking at the EPR space a little bit more closely and doing a lot of enforcement in that particular area. This slide is a little bit different to that. It just shows is how we utilize that big data to kind of just focus investigations, and there's quite a lot of outcomes there. Big deployments when it comes to the international space that, Basel-related matters, and this is just to show how that deployments look like. As I said, a lot of prioritization happening. Sorry, colleagues, I'm running out of time, so I think I just need to speed up to getting to main challenges. I think it would be remiss for me not to point this out, and I wanted to drive this message home, and it's really just how we are looking at this crime area in a little bit differently to what we have been doing before. So it is organized crime, a lot of organized crime in the waste and pollution sector. We are picking up perverse incentives to pollute rather than to rehabilitate the environment. It is seen as low risk crimes, but there's definitely high profits associated with it. I think let me leave it there. I stayed away from bringing up very specific examples, and the reason for doing that is a lot of the work is done against corporations or companies, and the examples there is quite controversial sometimes. So look, let me leave it there. I think I've run a little bit out of time, but let me pass it over to you, Julie. Thank you very much. I think we'll take questions.
Thank you very much for that. There is one question, if we have time to answer, for Vicky. Please briefly explain the exemption provisions under Section 40 of NEMWA, as explained on your slides and based on your mandate. I'm not sure if you would like to respond to that in a couple of minutes.
Yeah, I think that can be tackled by a grant. In a way, Grant, you want to help out on this one?
I think when it comes to exemptions and those things, and I hope I understand the question correctly, is that, as Mr. Luwate has pointed out, a lot of our work concerns prioritization. So when it comes to exemption provisions, or I suppose companies that, or activity or operators that operate under exemptions, they wouldn't be kind of elevated to a scale of criminal investigations and prosecutions. There would be a lot of facilitation when it comes to getting those into the regulatory net. So I haven't seen the question itself, but if that is just a short answer to that particular question, and I mean, we can engage offline as well if there's real interest in how we undertake it, but it becomes quite a bit tricky. We have not even gone into the matrices, but yeah, I think that is all that 15 minutes would allow us time for.
Yeah, and I think just to add, Chair, one needs to understand that we are sitting at the component that talks to that decision having been issued, and it's applicable, then we would need to ascertain compliance with that decision. So we are not necessarily going into the specific in terms of, for example, informing that decision, so to speak. So there's established mechanism for granting those exemptions from compliance with EAs, and those are sitting somewhere as director compliance, as director enforcement. We make sure that whatever has been granted is complied with, so to speak. So that also brings in the issue of the decision that is made. We are not necessarily going there. I mean, the minister may, in concurrence with the others, exempt a person from an activity. That is something that is sitting with the minister responsible for that decision. If they have all the information at hand to inform that decision, they may take that decision. Where we come in is that if the decision has been issued and they've given the paper as the minister, we now are responsible to make sure that whatever has been decided in that particular decision is complied with. And that is applicable to all the issued EAs, all the issued licenses, all the issued permisses, all the issued directives. So that's basically where we come in terms of that. So every SEMA has its own exemption provisions and also the conditions and steps in terms of how to undertake that. We, for example, don't make a decision if it can be granted or not. We can be consulted on other aspects, but we don't inform the decision. The decision is informed by the decision maker, taking into consideration the information on the table that informs that decision. We do come in after the decision has been made and a decision has been taken, and then we can deal with that. So I think colleagues needs to just understand that. Thanks, Jim.
Excellent. So I think I'd just like to thank you and your team for a really informative session, and also for highlighting areas where there is opportunity for us to engage further and provide input, and we look forward to that continued collaboration. So I'd just like to say thank you to everyone who attended today. Thanks for your positive inputs, and thank you to the DEFI team, and have a good day further.